This is the Litigator's Edge podcast with your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, a podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. It's such a privilege to have Tom Gardiner as my guest today. Tom is founding partner at Gardiner, Koch, Weisberg, and Rona, one of the most decorated firms in the Midwest. Tom, thank you so much for being here. It's truly an honor.
It's a pleasure to be here.
Tom, I'd like to start by asking you to please share a fun fact or a cringe joke for our audience. Which will it be and what is it?
Well, it has to be a fun fact, I guess. There was a famous lawyer named Jay Foonberg. And Jay Foonberg would lecture lawyers about how to market their practice, etc. And his third rule, Foonberg's third rule was work generates work generates work. So that's the quote I'm bringing to you today.
That's fantastic and so true and pretty timeless too. Thank you for sharing that, Tom. Also, I think of every attorney who makes the time to come on this show, such as yourself, as a superhero, and every superhero has an origin story. What's yours?
Well, I think it's a situation where I grew up. My mom would always read me stories about Abraham Lincoln. And so you hear some of those stories growing up and makes you want to become a lawyer. And so pretty much since I was young, I wanted to become a lawyer.
Oh, that's fantastic. Let's expand on that a little bit. You've had an over 4 decades long career practicing law, and you've seen so many milestones along the way. Can you maybe walk us through the sweep of your career and some of the key milestones that shaped who you are as a litigator and that made an impact on you?
Sure. Well, I started out of law school at Sidley in Austin, but I only worked there a short time period, and then I clerked for federal judge John Grady. And he was tremendous. He was so influential on my career. He was such a wonderful person, an outstanding judge. And before that time, I thought that I wanted to do real estate law. But once I clerked for Judge Grady, I wanted to do litigation. And during the time I was clerking for him, there was a huge trial that got nationwide publicity. It was a trial where a number of Chicago police officers were charged with having accepted bribes and being involved in drug dealing and turning their back so that drug dealing could happen. So in that case, there were 9 or 10 lawyers handling the case that were the primary lawyers. There were other lawyers involved in the case too, and it went for weeks. Well, the judge let me sit in for portions of that time. I had to write opinions, etc. in the meantime, but I still got a chance to see the different styles. And it was very interesting to me because I would think that the most flamboyant lawyer, the most entertaining lawyer was the best lawyer. And then Judge Grady would talk to me afterwards and he'd say, "What do you think?" And I'd say, "Oh, this guy was great. He was so entertaining." I don't know. I think you probably should take a look at this guy who was more understated, more professional, not as entertaining, but more effective. And he would make comments on different lawyers just in terms of presentation. And then just showing you how important he was to me. He had a few things that he said. He said, number one, you can never become a good lawyer if you work 9 to 5. If you want to work 9 to 5, take some other job, you'll never become a good lawyer. Number 2, he said, don't go back to the big law firm. He said you should try to get more trial experience. You should enjoy your career. You don't want to get stuck in a big law firm where there's kind of a procession, right? You get the big pay, the big house, and you're kind of stuck in your position. He said, don't do that. Why don't you go to the U.S. Attorney's Office or the State Attorney's Office and get experience that way? So those were key things that kind of set me on my path.
Wonderful. Can you speak a little bit more to your experience actually at in the attorney's office, both at the U.S. and at the state level, and how that sort of informed the rest of your career?
Well, I never went to the U.S. Attorney's Office. There was a hiring freeze on at the time. And then I took a job at the State's Attorney's Office. And the U.S. Attorney's Office called me back for an interview, but I was given some consideration where I could get to the felony trial court in 6 months, and that normally would take 2 years. So I basically got credit for my time clerking. So when they called me for the interview, at that point, I was already trying cases, and the U.S. Attorney's Office had a requirement that you did appeals for 2 years. Well, I had just been, as editor of a publication in law school, and then I was clerking. I'd already spent 2 years in the law library or more, right? So I said, I'm not even going to interview. I'll just keep doing the state's attorney job. And I learned a lot in that job because I got the responsibility early. I was there for 6.5 years. I ended up being a supervisor in the state's attorney's office of a bunch of trial lawyers. I did high profile type cases, so there were some fun things with the news and press meetings. It's a really good experience. And I got the supervisory position, even though I really didn't have any connections, but I had, some exposure to the state's attorney at the time, who became the mayor of Chicago, Richard M. Daley. And he just promoted what I believe was based on quality. So anyway, that's how the state's attorney's office was. And for me, I wanted to try cases. So if you wanted to do the work and try the cases, the opportunity was there. There were so many cases. In a law firm, it's a lot harder because the clients insist on seasoned people. You're the second or third chair. You might get one witness in a case. Much different world than the state's attorney's office.
That's fascinating. So it was almost like the state's attorney's office, or your position there, was almost a fast track to getting exposure to the quantity and quality of litigation that you were seeking.
Yeah, and the lawyers that I was against were all private lawyers. So they were private criminal defense lawyers, and they were generally good because I did a lot of white collar cases. I did some hired hit cases, solicitation to commit murder cases. So they were seasoned pros. And so you could learn a lot from those lawyers that you were against.
Outside of your practice and your firm right now, I noticed that you've been an adjunct professor at Northwestern Law for almost 2 decades. You're also an outside general counsel to over 100 companies, and you're involved with the International Practice Group, which is a lot. Can you speak to your roles in each of these positions and how perhaps they inform your overall outlook as a litigator and vice versa?
Well, at Northwestern, I had been asked to teach there years ago, but I actually initially said no because of just time constraints. But then I thought I probably should do that. And so I've done it for a long time. I do it more sporadically now than I did previously. And then I taught for the trial practice program, and then also for Judge Castillo, who became he was the chief judge of the federal district court, and he had asked me to teach there too. And it was a pleasure to teach for him. So what that gave me the opportunity to do was to give my thoughts to students that were considering becoming trial lawyers. And I thought it actually benefits the teacher as much as the student, because the students aren't stuck in their ways, right? So they'll come up with a new theory and I'll think, wait a minute, I never even thought of that theory. Will that really work or will that not? So it kind of opens your eyes a little bit that way. So it's a good experience, and it causes you to think through your positions instead of being reactive just based on experience. In terms of the International Practice Group, that's a group that's just a group of international accountants and lawyers predominantly focused on non-US locations. So that's really interesting because I get to meet lawyers from throughout the world and discover that they have the exact same problems that US lawyers have. Most of the people are managing partners like I am. So you hear what they have to say. And then there was a third one you wanted to?
Yes, your role as outside general counsel to over 100 companies.
Yeah, so that role is actually, of the 3, that's the most important by far. And that just came from me starting to represent some friends of mine. So I had some friends that I went to high school with, and they were in construction or in trades or in those types of areas. And when I was a state's attorney, I would meet with them at night. So I'd work during the day at the state's attorney, then I meet them at night in my basement, and they were just starting up their companies. So I'd incorporate them, and I would do contracts for them, and I would advise them as they grew. Once I left the state's attorney and went into private practice, there's more employment issues, there were corporate issues, there were acquisition issues, all those sorts of things. So these guys at that time, everybody was like 28, 29 years old, starting out, and some of those companies grew tremendously. And I had other companies that were established companies that for whatever reason had a connection, either a family connection or a friend connection, and they would come to me, and I would just work hard to make sure I gave them good advice. And then they gave more work as time went on. So when I left the state's attorney's office and went to the firm that is now Holland and Knight, it was called McBride, Baker and Coles, and then Holland and Knight swallowed them up. I had a group of people that were clients that I worked on at night and on the weekends. And then they were, it kind of happened to be a situation where I was growing professionally and their companies were growing. So then as that occurred, the next step was that those people who were executives of their companies would tell other executives. They just happened to hang out with other people like them, which you kind of would expect, right? So they would recommend me to other people, and it would just build. So there was a time where one of my key clients was getting married. We were, for the bachelor party, we were all playing golf. I think there were something like 16 people, so 4 foursomes. And out of the 4 foursomes, I represented everyone but one.
Wow. That's incredible, Tom.
So but I don't know how incredible it is, but it's fun. For me, it's fun because you're helping people out. You get to know them. The business issues are interesting. You think like a businessman. It positioned me better to be a managing partner later. So all those factors, I just really enjoyed it. I enjoy working with the business people.
That's wonderful. Shifting gears a little bit to your approach and your firm's approach to practice. One of the things that's emphasized is tenacity and then also compassion. And so when you're looking at high stakes litigation, from the outside at least, it looks like these two attributes can be at odds, right? And so how do you navigate that balance in your representation, ensuring tenacious advocacy while also maintaining compassion for those involved?
Well, I think there's a huge difference between tenacity and being mean-spirited or unprofessional. And I think that distinction often is lost. So you can be tenacious. You can file a motion and try to knock the legs out of the other side's case, but you don't have to be a jerk about it, right? So professionally with the other lawyers, I'll say, here's what we plan to do in this case. Is there a way we can deal with this situation? It's not, I don't say we're going to crush your client, etc. You're crazy. You're not handling things right. This is the dumbest thing I've ever heard. I've heard that said by other lawyers to me, but we try not to deal with it that way. And then the second part is when you think about the other side in cases, they're not necessarily evil. Right? So you can have a level of compassion. You can, if you're going to be effective, you're more effective if you can put yourself in the shoes of the other side and think of how they're taking things and how it makes you more effective actually with them. It allows you to communicate with their lawyer. It allows you to get to a solution in the case potentially. If you only think of the other side as the enemy, you cannot get to a resolution. You would have to, if that's the way you think, you can try 100% of your cases. but your clients aren't going to like that because it will cost too much. So that's, and we have lots of clients. We do medical malpractice and personal injury and nursing home litigation and wrongful conviction cases. We have lots of cases where we're representing people that we have tremendous compassion for. So on our side, it's easy to be compassionate for our clients.
Absolutely. Going back to your 4 decades in practice, Tom. So over these years, I have no doubt that you witnessed incredible transformations in the legal field, including in technology, which we'll come to in a second. But beyond technology, what has been maybe one or two of the most significant strategic or philosophical shifts in how complex litigation is approached?
Well, I think that it's a little bit like the commercial world, where you have companies that start their company with an eye towards selling their company, right? So I would say over the time period I've practiced, there's been more of a shift to resolution of cases. If you were to go back when I started, there were far more trials. So a trial lawyer would say, oh yeah, I'm a trial lawyer. I've done 50 jury trials, whatever it might be. Now, unless you're in the public service sector or you have a long career, there is no way you're likely to get 50 jury trials. You maybe if you're for an insurance company, possible, but that is extremely unlikely. Why is it unlikely? Because the cases settle like 93% of the time in the Northern District of Illinois. Even in the state courts, it's 85% of the time. And those cases take into account little cases, right? So when you get to the complex cases, most of them end up settling. So the mindset becomes, how do I get to the settlement, not how do I get to the trial? Now, lots of times it's the same thing. If you're positioning yourself properly for trial, you'll get to a settlement faster, right? But it's a different mindset than before. And that kind of influences everything. It influences how you look at the evidence that goes in. It influences the approach to deposition sometimes. The paper discovery is a massive undertaking for everybody in terms of interrogatories and document requests. And also the other thing is there is a dramatic change, I would say, on summary judgment motions in federal court, because the judges are far more likely to accept summary judgment motions and grant summary judgment than they used to be. So you see resolutions along the line, I would say, not necessarily earlier than before, but I think the whole climate's kind of changed in that regard because so many cases settle.
Very interesting. Against the backdrop of this changing climate, and going back to perhaps one or two notable cases that you might have had, can you share maybe one example of an unconventional strategy that you employed that gave you and your client a competitive edge?
I think that this is one that I haven't necessarily employed, but has been employed by John Rona, one of my partners, who's an excellent trial lawyer and also teaches at Northwestern. And that is the traditional approach in every case is to take the party depositions first. So the idea is that you lock in the party to their story in the case. Now, in medical malpractice cases, sometimes that's not the best thing to do. And so while initially we followed what everybody tends to do, now we're more inclined to kind of decide strategically whether it makes sense to do a defendant's deposition first or to do other witnesses' depositions and then do the party's deposition. It's a huge strategic decision to make because you can get burned, right? The person can see the other depositions and bob and weave a little bit in his deposition, or you can feel otherwise depending on the medicine, etc. So that's a kind of a deposition scheduling issue, which has big strategic plays. Same thing would apply to witnesses. What order you put witnesses in at trial. Same sort of thing. How do you tell your story? How do you tell it in a way that minimizes the other side's ability to do something? So those would be a couple things.
That's fascinating. Really quick on that. What's the upside of not going in the order that most attorneys typically do?
Well, the upside is that if you think you have the ammunition, you gather more ammunition during the course of discovery with other people.
I see.
So you may learn things that you wouldn't know originally. So you're right out of the gate on the case, you have written discovery, you do your deposition, then you do another 15 depositions. Well, after the 14th deposition, you're thinking, well, wait a minute, I know things that I would have loved to ask the defendant when I did his deposition, but I don't have another opportunity.
That makes a lot of sense. Awesome. Thank you for sharing that, Tom. Switching gears to technology now. So obviously as a founding partner who's seen the evolution of legal tech from where it was a few decades or certainly even a few years ago to today, what is your and your firm's approach in adoption of technology, innovations and AI and so forth? How do you balance sort of the tried and true methods of litigation with all these new tools that are out there?
Well, that's a really good question and one that I think everybody is debating right now. It's almost impossible to pick up a legal publication without AI mentioned. So every conference, there's an AI session. It's the most attended session. It's a whole new era. The case management software and things like Clio and those related programs, very important, very influential, very necessary at this point, I'd say, for having a law firm that can function well, having the access to the information across the different lawyers and remotely. That's all kind of passe now, right? That was all COVID and post-COVID, pre-COVID too, but COVID sped everything up in that regard. Discovery programs have become important in terms of documents. They have always been important. They are always dangerous in part because you can never, if you have the wrong terms, you don't get what you're looking for. And they aren't a substitute for knowing your documents and knowing your case. And I think it's a trap. Some of the traps of the technology is that you can rely so much on it that you overlook things. Let's face it, our job is, in cross-examination at least, is to make the little big and the big little, right? So a paragraph in a letter can be a big factor in a case, and missing it can be a big factor in a case, right, if you don't use it right. In terms of the AI, there's no doubt that this is going to become more and more important. The question is reliance and exclusive reliance, and that's where people are getting into trouble. It's like in college where somebody gets cliff notes or some summary of a story, and they read the summary, and then they get the test, but they don't know the things in between. So there have been cases out there and rules promulgated now by the different courts limiting the use of AI. And you can't submit a brief based on AI without your independent evaluation of the cases, et cetera. Now, there are going to be more cases on this because I know how this is going to work. Lawyers are the greatest procrastinators in the world, and they'll be working on a brief. It will be due tomorrow, and they'll say, I got to figure this out. I only got a X number of hours to go. I'm going to rely on AI here. And it'll either blow up in their face or it'll work out fine. But I think there has to be the barriers or the double checks to make sure you don't make a mistake. But it's only going to accelerate. All this is going to accelerate. I don't think it's going to eliminate law jobs. It's not going to, well, I guess I would say this. It's not going to eliminate sophisticated law jobs. If there's something that's more rote or document intensive that is just cranking out document after document, that might create a problem.
That's fascinating. So I have two follow-up questions on that sort of span the spectrum between 2 points that you mentioned. So one of them is, what resistance have you seen in the field in terms of embracing new technologies such as AI, and how do you advise attorneys to sort of not overcome it, but to sort of manage it or evaluate these new technologies in light of these threats to jobs and so forth? That's my first question.
Oh, well, I don't know it's kind of like the horse and buggy in the car, right? You're going to end up using a car. So, so you might as well embrace the technology. And if the lawyer can't embrace the technology, let's say senior lawyers are more reluctant to embrace the technology, right? You have to have other people that embrace the technology. But I actually think the senior lawyers don't have a whole lot of choice either. You can't just rely on other people to do everything. You have to have an understanding of it. You have to know enough to know what to adopt or not. You have to be, from a managing partner point of view, you want to have people try things out before you sign up for some of these subscription services, et cetera. They're wildly expensive. So, because there's a per attorney cost, it's one thing if you're a solo or a small firm, but the bigger you get, the more expensive they get. But I actually think that what will change will not be the usage will just increase, everybody using things. I think the cost will be driven down eventually, and everyone will be using things. AI, technology, whatever it might be.
Yep, makes sense. Last few questions, Tom. So given that you've seen the sweep of innovation, especially, you mentioned pre-COVID and post-COVID and now in this age of AI, where do you see the biggest opportunities for innovation over the next 3 to 5 years? And what I mean by that is where should AI companies be focusing their energies to help attorneys such as yourself?
I think the biggest innovation would be the improvement in document review, improvement in kind of the cross-checking things that lawyers are bad about. For example, if you have references within a document to internal paragraphs, or other things that are inconsistent, I can picture AI at some point saying, paragraph 3 doesn't make sense in light of paragraph 9. So, and on a larger scale, when you have longer documents, you have a 100-page document, it's hard for the human brain to necessarily remember the second sentence of paragraph 3 when you're on paragraph 143. So I can see things like that, a little bit like you see with Word, right? Where you don't have the noun-verb arrangement right. I see it being way more expansive and helpful, actually.
Sounds great. All right. Just a couple more questions as we wrap up here. So, given your career and given the mentorship that you had under personalities like Judge Grady, what advice would you give today to an attorney who is maybe early or mid-career and is looking to navigate today's landscape, social and technological and landscape with everything else that's going on out there?
Well, I actually think nothing has changed in large part in this respect. My view is that you should take the job that you want, not the job that pays you the most. And that's hard to do. But what I did was I went from a big law firm. I took a pay cut to be a judicial clerk. I took a pay cut to become an assistant state's attorney. And then I started reversing things. But that time period there covered about 8.5, 9 years. So I took pay cuts, and while my friends were living better than me, in the long run, it helped me a lot. So I think that young lawyers and mid-term lawyers should think of the long term, not the short term, and they should be willing to make the sacrifices short term so they don't regret it in the long term. And that's why I see a little bit the interview process for people, I think should be focused on the work that they want to do and will enjoy, not based on what they will get. In the professions, it just seems to me that if you're dedicated and you do a good job, and especially if you're enjoying what you're doing, you convey that to other people. They'll want you as your lawyers, and you're going to be successful. So that's long term, not short term. Personal interest, not money.
Wonderful. That's a wonderful way to close. Final question for you, Tom. What's a question that I should have asked you, but I didn't?
The question should be, how do lawyers get the ability to determine what they want to do? So Most of the time, what happens is lawyers graduate from law school, they've taken a group of classes. While they've liked some classes, most lawyers don't know what they want to do. So I think that it's imperative that they do something like doctors do, where they do rotations. They go to a firm where they can sample different things and get the experience in different areas and then decide what they want to do. Otherwise, they get pigeonholed early and they're kind of in that area and it's hard to break out. It's better to have initial exposure to the area and then make a decision. And one of the lawyers in our office, Faizan Khan, thought he wanted to be a litigator. And we gave him some real estate and probate stuff to do and estate planning. And Faizan said, I love this stuff. And he's never looked back. But he had the exposure that he wouldn't have had. When he interviewed, he thought he wanted to be a litigator. We just gave him a taste. So I think that it's important for lawyers to consider a number of areas of practice before committing to a final area of practice.
Wonderful. Well, Tom, this has been a wonderful conversation. You've been very generous with your time. I really do appreciate it. And I'm sure our audience will as well. So thank you so much for your time, Tom. And yeah, we'll see you again soon, I hope.
Sounds good. It was fun.
Yeah, take care.
Bye.
Bye.
Thanks for listening to this episode of the Litigator's Edge podcast, brought to you by Threadio.